use this opportunity to remind you about a few things. Firstly, as regards today's seminar, there are feedback forms to be completed. So when you're finished, if you don't mind filling out one or two of those forms, that will be excellent. We really do value the feedback. It's very important to us, and it helps us to tailor our offering in future seminars. If you could do that, we'd be very, very grateful indeed. Secondly, if today's seminar is not enough, or you want to learn more about what we do and property work in general, we've got a property roadshow where various members of the property team will be travelling around the West Country in South Wales. So they'll be in Bristol, Cardiff, Cornwall and Devon delivering lectures in person. If you'd like to know more about that, details will be on the website, and I think Sarah has shared that in the chat. And if that isn't of any interest, or that's not enough, then there's more. In the autumn, we'll be offering a further webinar programme from the property team, and details will be going up on the website shortly, so keep an eye out for that. We have, I think, probably enough people to make a start. So I will just share my screen and we will get underway. Okay. Well, for those who've just dropped in, welcome, good afternoon. This is the third in our property webinar series this spring, dealing with property issues in connection with Trusts of Land and Appointment of Trustees Act in particular. This third instalment is dealing with proprietary estoppel and how that can impact upon forming, disposing of and varying beneficial interest in land in particular. We've only got a 50-minute slot, so we've condensed our talk as much as we can down to some key useful points, hopefully that you will be able to take away and find of some use and interest to you. I'm going to start by looking at some of the core ingredients of proprietary estoppel. Now, those of you who have who practice in the field will be aware that there have been a very large number of high-profile cases in recent years, and over the last 30 years or so, the courts have struggled really to set out a definitive statement of the doctrine of proprietary estoppel. And we've been lucky, in particular, in connection with two recent-ish cases, where in the case of Guest and Guest, which Annie Sampson is going to talk to you about after my section, the court has set out how one goes about quantifying the remedy in proprietary estoppel cases. And shortly before that, the Court of Appeal set out some core principles as to how one goes about determining whether or not there's a proprietary estoppel claim at all. And that's a case called Davis and Davis. Now, Davis was a very much a classic proprietary estoppel claim, save that rather than being the hard-done-by son who had worked as a man and boy on the farm, it was the hard-done-by daughter. Arian Davis had spent 25 years working on her parents' dairy farm in Wales. It was fairly arduous, unrelenting work, and she missed out on lots of opportunities that were available to her sisters. And this led to her being called the cowshed Cinderella in much of the press. The relationship that she had with her parents was particularly difficult and fractious. She was often left on the farm, unattended, left to deal with matters on her own. There were fights and arguments to the point that she actually left the farm on 3 separate occasions after fallings out with her parents, although she did reconcile each time and return to work on the farm. The trial judge at first instance, and indeed the Court of Appeal, accepted that she had a proprietary estoppel claim, but they did find that she'd not always kept to her side of the bargain, and therefore she'd failed to show that she'd actually positioned her whole life on the basis of her parents' assurances and promises. So an award of £1.3 million at trial was reduced to £500,000 on appeal. But that's not really what's the interesting takeaway from the Davis case. What's useful from a practitioner's point of view is that in the Court of Appeal, Lord Justice Lewison set out 9 principles that one should work through and apply in proprietary estoppel claims. And I'm going to look at the first 5 of those principles when deciding whether or not there's a claim at all. And Annie is going to unpack the others when looking at the remedy. So firstly, in deciding whether an equity has been raised, and if so, how to satisfy it, the court is conducting a retrospective exercise, looking backwards from the moment when the promise fails or falls to be performed, and asking whether in those circumstances, would it be unconscionable for a promise not to be kept, either in whole or in part? It comes from a Supreme Court case called Thorne and Major, fairly well-known case. Next, and importantly, the ingredients necessary to give rise to an equity are an assurance of sufficient clarity, reliance upon that assurance by a claimant, and detriment suffered by the claimant in consequence of his reasonable reliance. Again, that comes from Thorne and Major. Now, no claim based on proprietary estoppel, the court said, can be divided into watertight compartments. So the quality of the relevant assurances might influence the issue of reliance. Reliance and detriment are often connected, and whether there's a distinct need for mutual understanding may depend on how all the other elements are formulated and understood. So really, rather than it being a checkbox exercise, the court needs to stand back and look at the whole landscape of the evidence in the case to decide whether or not a proprietary estoppel is made out. Often in these cases, there'll be a question of what is the detriment that has been suffered, or was it sufficient detriment suffered to give rise to a claim? In Davis, the court said that detriment is not necessarily expenditure of money or other quantifiable financial detriment, so long as it's something substantial, something meaningful. And the court said that the requirement must be approached as part of a broad inquiry as to whether repudiation of an assurance is or is not unconscionable in the circumstances. So effectively, if you like, looking back from the date of the trial, when the obligations, when one party is looking to resolve from the obligations and the other party is looking to enforce them, having regard to the reliance and the detriment suffered in consequence of the assurances, is it unconscionable to allow that party, the promise maker, to walk away from their obligations? That's really what the court is doing. Now, there needs to be a sufficient causal link between the assurance relied on and the detriment suffered. They can't be completely unconnected. It needs to be detriment suffered in reliance upon that assurance. So something that they wouldn't otherwise have done had the assurance not been made. So those are the core ingredients to getting your estoppel claim off the ground. So let's move on to look at two recent cases of proprietary estoppel decided earlier this year. Now, the first case I want to look at is a case called Mate and Mate. It's from 2023. This is a farming case, but an unusual farming case. Shirley and Donald Mate had 5 children. Julie, who was the claimant in these proceedings, Andrew and Robert, their sons, Julian Robson and Virginia Boothroyd. The farm was a fairly substantial dairy farm in Huddersfield, West Yorkshire. Donald and Shirley were partners in a milk bottling and milk retail business for many years, and they brought their sons in as partners shortly before Donald's death. By late 2007, Shirley had encouraged Julie to look into the potential for development of the site. So there was a particular area of about 40 acres or so, known as Netherton Moor, which had the possibility of obtaining planning permission for residential development. So Julie busied herself on looking into the planning issues, obtaining planning, teeing up developers, and entering into or teeing up an agreement, an option agreement with a developer, with Persimmon Homes, to develop this site. Planning permission was granted for 250 houses, and the developer exercised its option for £9 million and bought the site. So Julie said, from the late 1990s onwards, Shirley had made promises, and Mum had made promises to me that in the event that the farmland was sold, the proceeds would be shared, not just between her and the 2 sons, but also the 3 daughters. Julie said that Shirley had said on several occasions from 1998 to about 2003 that Julie and her sisters would benefit, and she couldn't see anything happening at the moment, but if anything happens to the farm, the girls would be, quote, looked after. And Julie said that there were a series of generic promises over a period of time, and 2 specific promises made in 2004 and 2020 or 2020. Now, the evidence at trial didn't really play out to Julie's advantage. It was quite clear, the trial judge found, that none of the pre-2008 promises that Julie was relying on were sufficient to entitle her to believe that she would receive an equal share of the proceeds of the farm. There was no documentary evidence to back up what Julie was saying of any specific or generic promises having been made. And in fact, the available documents tended to suggest that no promises had been made at all. And by 2020, solicitors who were instructed on Julie's behalf wrote to her mother, and they set out an account which was large, well, not entirely, but somewhat inconsistent with what Julie was saying at trial. And the judge said that, I find that by this time, Julie had convinced herself that Shirley had promised her that the sale proceeds of the windfall would be shared equally in this way, when in fact, Shirley had never made such a specific promise. Nor do I consider that Shirley was ever specific about what proportion of the windfall she and her daughters would receive. I find that on the occasions when Shirley spoke to Julie about the sale of farmland in general, and the sale of Netherton moorland in particular, she referred to the daughters being looked after financially, but was never specific about what share of the windfall proceeds she hoped to pass on to them. So the judge, in dismissing the claim, said, accordingly, the fact that no promise of sufficient clarity was made to Shirley, by Shirley to Julie, means that no equity arises on which Julie is able to found a claim in proprietary estoppel. Given that Julie has failed to establish that a sufficiently clear promise or assurance was made to her by Shirley, it follows that she cannot have relied on any such promise or assurance, and the issues of reliance and detriment do not fall to be considered. So that's a case, mate and mate, which was dismissed, the claim in proprietary estoppel at least, was dismissed on grounds that there wasn't sufficiently clear evidence of promises having been made, and the promises that were made were not sufficiently clear as to be capable of being reasonably relied upon by Julie in the way that she claimed that she did. Now, the next case I want to mention to you is really very, very interesting case indeed, called Gladstone and White. Gladstone and White involved effectively a stately home and its grounds and lands called Wootton House. David Gladstone issued possession proceedings against Miss Lee White in connection with Wootton House, which was his property. Wootton House was worth about £50 million, according to the evidence, and Lee White, friend of Mr. Gladstone's and his late wife, was in occupation of it. David was a retired diplomat. He was, by the time of the trial, 87 years of age. He'd given a witness statement, but because of his failing health, his solicitors had called evidence to show that he wasn't capable of giving evidence. So in the event, he didn't actually give evidence at trial. His former wife, April, had died in January 2014. And David had moved shortly before or during the first lockdown to the north of England, where he subsequently married Mary, his second wife, in October of that year. Lee had met David and April, David's first wife, in the early 1990s. By 2002, David and April were treating Lee as a very close relative, as a close family member, and in fact there was email traffic and other anecdotal evidence where David had referred to Lee as his surrogate daughter. Lee defended the possession proceedings brought by David on the grounds of proprietary estoppel. She said that promises had been made to her that she would inherit Wootton House on Lee's death, and also that she would have the use of 2 properties in London, which were valued at about 7 million. She said that she'd relied upon these assurances and she'd effectively positioned her life around them, and it was now unconscionable for David to resile from those assurances and look to evict her. She claimed that the assurances were first made to her during a lunch in London in 2007 and then repeated subsequently at other meetings. Now, it's right that they were very close, they were very good friends, and it seems to be the case on the evidence that she was effectively treated as a daughter to them. At around the time of the meeting in 2007, David and April had met with their solicitors, professional advisors, and Lee had attended. Lee was a solicitor. There was estate planning advice given at that meeting, and there was no suggestion at that meeting that Lee would be a beneficiary of the trusts that they were looking to set up. Lee said that despite that, assurances were repeated to her on many occasions over the years, and she effectively positioned her life on the basis that she was going to inherit Wootton House. She moved to the property to enable her to run it and its estate. She moved her son to a nearby school. She lived away from her daughter and her husband during the week, and she wound down her legal practice to enable her to take on a full-time role in managing the estate. So that was her detriment. Mr. Justice Trower, in a fairly detailed judgment going through each and every occasion on which Lee said an assurance had been made, and then in turn through the detriment, rejected her evidence on the assurances. And he said that even if Lee had been given the clear assurance about absolute ownership that she now claims, she must have realised almost immediately either that David had not articulated what he meant to say in a manner that reflected his true intention, or that she had misunderstood what had been said. It is also striking that Lee said nothing at the time about this disconnect, an omission which points to a conclusion that the assurance in the terms advanced was never given, or even if it was, that it was not a statement, assurance, or promise on which it was safe or reasonable for her to rely. I am satisfied that it was unreasonable for a solicitor in the position of Lee to rely on the assurance she now says she'd been given at the lunch, in the knowledge of the contents of the 2008 wills, you recall that was a meeting that she was in attendance at, and with no written record of the inconsistent promise she said that David had made. So that was a case where the court said, well, yes, you may say these assurances were made to you, but the clear contemporaneous evidence is that you were present at meetings with professionals where instructions were given by David and April in 2007, 2008, which provided for Wootton House to be left into a trust of which you were not a beneficiary. So even if David and April had said to you at this meeting, we'd like you to take on or manage or succeed to or whatever Wootton House, you as a solicitor could not reasonably have understood that to be something you could rely upon to your detriment and build a claim in proprietary estoppel. And then feeding into the reasonableness of reliance, the judge said this: even if David had expressed himself in a manner which appeared to convey a firmer promise of future entitlement than was expressed by his 2015 will and letter of wishes, it was unreasonable for Lee to restructure her life to her detriment in reliance on what she thought he had said. So far as what Lee was told at the lunch, I am satisfied that she was entitled to conclude that David wanted her to have an important role in Wootton going forward, all the more so after he and April had died. But even if she had convinced herself that what he had said, that come what may, she would not be the appointed heiress, she termed herself, the context in which this assurance was given was not one on which, in my judgment, it was reasonable for her to place substantial reliance in ordering her affairs going forward. So effectively what the judge was saying is, look at the context. No reasonably informed person such as yourself, privy to what was actually going on, could have believed these assurances such that it would have been reasonable in the circumstances to rely upon them and to build your life based upon them. So the judge went on then to look at the detriment that Lee said she suffered. On the detriment, he said this: detriment does not have to be financial, but it must be substantial. Establishing the detriment is part of the broad inquiry as to whether or not repudiation of any assurance is unconscionable, and there must be a sufficient causal link between the assurance relied on and the detriment that is asserted. Put another way, it is necessary for Lee to prove each element of detriment on which she relies and to demonstrate that, taken as a whole, the detriment is sufficiently substantial, having regard to the fact that the court is engaged in a broad inquiry as to whether in all the circumstances, repudiation of any promise or assurance is not unconscionable. So what the judge is saying is you need to prove your detriment. You need to prove each and every element of it. You need to prove that it was done, an act taken or a forbearance in reliance upon the promise that was made. And then standing back and looking at all of that detriment that was caused by or causative to the assurance, in all of those circumstances, is it unreasonable for those assurances now to be backtracked upon? And then one asks whether or not it's unconscionable in all of the circumstances. And the judge said this, putting the final nail in the coffin of Lee's case. Even if Lee had been assured by David that she would inherit Wootton in any event, and even if it had been reasonable for her to rely on any assurance, she would not have established the necessary substantial detriment to complete her cause of action. In these circumstances, even if the assurances had taken the form alleged by Lee, I am not satisfied that it would have been unconscionable for David to change his mind as to the identity of the person he wished to take on the running of Wootton for the next generation with a promise of inheritance. So that was the end of Lee's claim. So looking at those two cases in particular and drawing together some of the strands from a number of authorities following Davis and Davis, there are a couple of themes that one should have in mind when looking at either building or attacking a proprietary estoppel claim. It's vitally important, given that these cases are turning on first-hand accounts of witnesses, which often will be unsupported by documentary evidence and often not supported by third-party independent evidence, that it's vitally important that a consistent account of assurances is given, even from the earliest skirmishes of the case. In particular, pre-action correspondence and letters and meetings. What do people say at the earliest stages, and how does that change when it feeds into their pleadings and in their witness statements? Secondly, you should always try to find, if you can, corroborative evidence. Typically in these sorts of cases, it will be difficult to come by, but in farming contexts, one will often find evidence from accountants, financial advisors, farm managers, or business consultants and suppliers. And those sorts of independent people who maybe are dipping in and dipping out of the business on a ad hoc basis might be able to shine some light on what was actually going on in the interactions between the person who made the promise and the claimant at trial. I've listed corroborative contemporaneous evidence. Often you're not going to get that in these sorts of cases, but you'd want to look for it. In the mate and mate case, there was correspondence passing between the parties which didn't bear out what was said. And again, in the Gladstone case, there was attendance notes of meetings which simply just didn't corroborate what Lee was saying about her claim. It's useful to have a narrative that fits. So if you're able to show that the farmer, the parent, or the homeowner in the case of Gladstone case, there's a story. And if you can fit the promises into that story so that it just makes sense, that the narrative of how all of these people build their lives and how they position themselves, if it's a clear and consistent and sensible account, even if you don't have corroborative evidence of the promises, all of that builds into the picture that by their words and conduct, which comes from Thorner and Major, by their words and conduct, it's more likely than not that these promises were made and then subsequently relied upon. On the detriment, you need to show meaningful, substantial detriment, evidence of life choices made, career paths not followed, hours worked versus income received, poor and substandard accommodation, poor and substandard working conditions. All of that will feed into detriment suffered. It's important to show as a claimant what that claimant would have done differently had the assurances not been made. What could they have done with their lives? How could they have built their future? And opportunities that have been missed, that sort of unquantifiable detriment is going to weigh quite heavily on a judge's mind if he or she finds that the assurances were made. And then finally, you need to show that a demonstration, that a departure from those promises and assurances gives rise to a real hardship, such as to be unconscionable. And if you find that, then you unlock the doors, and the court then moves on to look at what remedy to award in your proprietary estoppel claim. So without straying any further, I will hand over to Annie Sampson now, who's going to address the issue of quantifying quantifying remedy in proprietary estoppel claims. So over to you, Annie. Thank you.
Thanks, Chris. I'm just going to share my screen, I hope. There we go. I hope that you can all see those slides now. Good afternoon. And yes, I'm going to pick up where Chris left off and look at the court's approach to remedy in proprietary estoppel claims, and in particular, whether the position is any clearer after the Supreme Court's decision in Guest and Guest. But in order to do that, first, I'm going quickly to consider the position before Guest by looking at two earlier authorities, starting with the 9 principles distilled from case law by Lord Justice Lewison in Davis and Davis. Chris has already taken us through the first 5 of those principles, and now I'm going to go through the remaining 4, which deal with the appropriate remedy. Firstly, it was suggested that the focus is on what is necessary to avoid an unconscionable result, which is perhaps more straightforward in its expression than in its application, as is underlined by the very different approaches taken in the Supreme Court in Guest to what the unconscionability is that the courts are trying to avoid, let alone how it should be avoided. And so this is something that I'll return to. Secondly, and less controversially, any benefits enjoyed by the claimant as a result of their reliance should be weighed in the balance against the detriment suffered, although that is not something to which the Supreme Court turned its mind in Guest. Thirdly, and more pertinently to the issues in Guest, Lord Lewison suggested that proportionality was at the heart of proprietary estoppel, and in particular that there must be proportionality between the remedy and the detriment, which is its purpose to avoid. Although he went on to qualify this by noting that this does not mean that the court should abandon expectations and seek only to compensate detrimental reliance, following Guest, this statement of principle would still likely now be considered incorrect. Proportionality is no longer at the heart of the doctrine, but can provide a useful cross-check, and it's not detriment which has to be avoided, but unconscionability. Finally, Lord Lewison reiterated that the court has a broad but not unfettered discretion as to the appropriate remedy. And I'll go on to consider the extent to which the Supreme Court has or has not set down a clearer, more principled basis for awarding relief in proprietary estoppel claims. Another helpful principle is the spectrum described by Lord Walker in Jennings and Rice, which is a concept of which Lord Briggs approved in Guest. This was a suggestion that all proprietary estoppel cases fall on a spectrum, with those circumstances where there is a mutual understanding on clear terms, which falls just short of being a binding contract at one end of the scale, and less clear and less consistent assurances, but on which it was nonetheless reasonable to rely at the other end of the scale. In those circumstances where there was a clear mutual understanding, it was suggested that the court's natural response is to fulfill the claimant's expectations, with the court then moving further away from fulfilling the claimant's expectations as it moved further away from quasi-contractual circumstances. But that does not mean, but regardless of where a case fell on the spectrum, Lord Walker was clear that the court should not use the detriment to define the appropriate relief, particularly given the difficulty which is often faced in quantifying the detriment in monetary terms, an issue by which Lord Briggs was also concerned in Guest. However, it is clearly not only where on the quasi-contractual spectrum that a case falls which is relevant to assessing the appropriate remedy. Lord Walker also suggests that the conduct of both parties can be relevant to what relief should be awarded, as can whether there is a need for a clean break, whether the promisor's circumstances have changed, any claims of others on the promisor's estate, and the effect of taxation, matters to which we'll return in the context of Guest. And having considered a couple of key pre-Guest authorities on relief and proprietary estoppel claims, I'll turn now to Guest itself, starting with just a brief summary of the facts. As is so often the case with proprietary estoppel claims, this case arose in the context of a farming family. David and his wife Josephine farmed at Tump Farm, where they also lived. They had 3 children: Andrew, the claimant, his brother Ross and sister Jan, and from an early age, Andrew understood from his father that the farm and the business would be his. And albeit unbeknown to Andrew, his father made a will in 1981, leaving the farm to Andrew and Ross in equal shares with a pecuniary legacy to Jan. From 1982, when he left school aged 16, until 2015, when the family fell out, the partnership was dissolved and Andrew was offered instead a farm business tenancy, Andrew had worked full-time at the farm for more than 30 years. Following that falling out, David's assurances were finally reneged upon when, in 2018, he made a new will, leaving nothing to Andrew. Following on from that factual background, one of the more perhaps niche lessons which can be taken from guests is that if you're going to deny having given assurances to your son that he will inherit the farm, as David sought to do at first instance, it would likely be best to avoid giving newspaper interviews referring to such an intention and posing for an accompanying photo on location at the farm. And perhaps unsurprisingly, particularly given that newspaper article, the first instance judge found that an equity had been established, but he did not consider that these circumstances were quasi-contractual, as the extent of what Andrew could expect to inherit was not sufficiently certain for that to be the case, particularly taking into account Andrew's own recognition of the fact that his siblings too expected to inherit from their parents, such that it could not be as straightforward as his expecting to inherit the whole lot. Nonetheless, though, the judge's focus appears to have been on what Andrew expected to receive, and that is so despite his only ever having expected to inherit on his parents' deaths, while the proceedings granted relief in their lifetimes. In light of the acrimony between the family and the consequent unreality of requiring them to continue to live and farm together, the judge also thought there was appropriate to grant relief, which achieved a clean break between the parties. And taking this into account, the judge was willing to grant relief, which he thought would make it likely that the farm would have to be sold. Again, despite there being a significant acceleration of Andrew's expectation as a result of the relationship between the parties having broken down in his parents' lifetimes. And it's also notable that this decision was reached apparently in the absence of any evidence as to the tax implications of a lifetime disposal of the farm. Instead, this difficulty seems to have been dealt with simply by ordering that the parties share the tax consequences between them, whatever they might be. With these matters in mind, the judge ordered that Andrew should receive, firstly, 50% of the market value of the business, and secondly, 40% of the market value of the farm, less a life interest in just the farmhouse in favour of his parents. And that relief seems to have been modelled on an earlier will of David's, and does not appear expressly, at least, to have included any discount for the acceleration of Andrew's interest due to the relief being granted in his parents' lifetimes, save perhaps for the life interest in the farmhouse. So the parents appealed and were granted permission to appeal on 3 grounds, all in relation to the relief granted. Firstly, it was suggested that the court should have gone no further than was necessary to avoid an unconscionable result, when instead it was said to have based the relief awarded on the claimant's subjective expectation, which seems at least partly to be premised on the idea that the detriment suffered should have defined the award instead. There is also the suggestion that the court ought to have considered an offer by the defendants, allegedly made with a view to avoiding an unconscionable result, as being the appropriate remedy, presumably being referenced to the offer of a farm business tenancy, which was a suggestion which, to some extent, found favour with Lord Legate in his dissenting judgment in the Supreme Court. Secondly, albeit a very similar criticism to the first round of appeal, it was suggested that the court had gone beyond the minimum equity necessary to do justice, which could instead have been achieved by way of a charge on either the business or the farm. However, it's not clear whether this was intended to address the issue of acceleration, as well as the extent of the detriment suffered, and neither is it clear how such a charge would work, such as whether it would enable Andrew nonetheless to force a sale, let alone how much it should be for. Thirdly, as the claim had arisen during the lifetimes of Andrew's parents, rather than engaging meaningfully with the issue of acceleration, it was suggested that the issue should be left in abeyance until they had died, when relief could be considered in the circumstances in which the promise was supposed to be performed. The Court of Appeal, however, dismissed David and Josephine's appeal, so they appealed again, and that appeal was heard by the Supreme Court. This time, although all the judges would have allowed the appeal, they were divided 3-2 as to the reasons for allowing the appeal, and consequently, what relief they would substitute for the relief ordered at first instance. I'll consider first Lord Legate's approach in his dissenting judgment, as I think it provides helpful context for Lord Briggs' leading judgment. The crucial difference in Lord Legate's approach is his focus on detriment. In his dissenting judgment, although he recognised that it is an attempt at going back on the promise, which is the conduct which ultimately gives rise to the claim, Lord Legate nonetheless framed the relief by reference to detriment suffered. The aim of the remedy is to prevent detriment, he said. While Lord Legate goes on to suggest that there are 2 ways of preventing detriment to the promisee on the promisor seeking to renege on an assurance, one being to compel the promisor to perform the promise, or award compensation to put the promisee in as good a position as if the promise had been performed, or the expectation basis. The other being to compensate the promisee for their detrimental reliance, the detriment basis. His view that preventing detriment is the aim of relief in proprietary estoppel cases, and the suggestion that the court should have ordered the minimum to achieve this aim, rather than more broadly the minimum to achieve justice, means that compensation for the detrimental reliance of the promisee would still likely be the result of his approach. And it is notable that he frames relief as a binary choice between compensating expectation or detriment, rather than those being at either end of a sliding scale. Similarly, while Lord Legate also drew a distinction between cases where the promise had fallen due for performance at the time of the proceedings, and cases where performance of the promise remained conditional on an event which had not yet taken place, thereby raising the issue of acceleration, his interpretation of the aim necessarily being to avoid detriment does mean that his starting point, even where the promise has fallen due for performance, seems still not to be the fulfillment of the promisee's expectation, unless the reliance loss were very difficult to quantify in money terms and not clearly disproportionate to the value of the interest promised. And where the reliance loss is considered clearly disproportionate, it is not a matter of cutting down what might have been awarded to fulfill the promisee's expectation. But instead, Lord Legate suggests that the court should immediately move to seeking to compensate just the reliance loss, despite already having noted the difficulty of attributing monetary value to the same. As to cases where the promise has not yet fallen to be performed, firstly, the starting point for relief is suggested to be an offer made by the promisor, which represents a genuine and reasonable attempt to prevent the promisee from suffering detriment due to the promisor seeking to go back on the promise. So, as previously indicated, it seems that Lord Legate was open to the idea of the promisor, the very person seeking to go back on the promise, also being in a position to indicate the parameters of the appropriate relief for the promisee as a result of their seeking to go back on the promise by making an offer. While it is recognised that Lord Legate required such an offer to be genuine and reasonable, it still seems like an odd starting point. In the absence of an offer from the promisor, Lord Legate suggests that the approach to relief remains a binary one between compensating the expectation or compensating the detriment. But he does go on to note that if the award is made by reference to the expectation, it must be discounted for the contingencies to which the performance of the promise was subject, such as the fact the promisee has ceased working on the farm early, as well as any acceleration. Applying this to this approach to the facts of guest, Lord Legate concluded that enforcing the promise was not an option, and apparently neither therefore was awarding compensation to put Andrew in the position he would have been had the promise been performed. As a result, Lord Legate sought just to compensate Andrew's reliance loss, which he described as an award of compensation calculated to put Andrew, so far as money can do it, in as good a position as if he had not built his career on those promises. Despite framing Andrew's detriment quite broadly, Lord Legate nonetheless suggested an award which represented lost wages and interest, which seems to me to represent a narrow interpretation of what he lost by building his career at the farm on his father's assurances. So in place of 50% of the farming business, worth approximately £250,000, and 40% of the farmland, worth approximately £1.1 million, subject to an interest in the farmhouse in favour of Andrew's parents and tax, he would have awarded just £610,000. So with Lord Legate's approach in mind, I'll now look at Lord Briggs's leading judgment. His approach was, as previously noted, very different. Lord Briggs was reasonably clear, and consequently it is now reasonably clear, that the detriment-based approach is wrong, particularly as it overlooks that in the repudiation of the promised that it is the repudiation of the promised expectation which constitutes the unconscionable wrong, and is the prevention or undoing of unconscionable conduct, which is the aim of the remedy in proprietary estoppel cases, not either the fulfilment of the expectation or the compensation of the detriment. But nonetheless, as a result of this being the aim, to prevent unconscionable conduct, the normal and natural remedy is to hold the promisor to his promise. So we've moved to the expectation basis. Although in support of this, it is also said that this is the simplest way to address the unconscionability, which is perhaps not the sturdiest of legal foundations. And the relevance of detriment to the assessment of the appropriate relief is as a cross-check to check that the remedy is not, without some good reason, out of all proportion to the detriment. But even then, it is only likely to be of much use if the extent of the detriment can readily be identified, which Lord Briggs also observes it often cannot be. For example, he notes that the counterfactual of an education and working life of a very different kind may be too speculative to quantify. So detriment is of far less relevance to the appropriate remedy than was likely thought prior to Guest. However, that is not to suggest that fulfilling the expectation is the end point as well as the starting point. Instead, Lord Briggs identifies other factors to take into account beyond just whether the expectation is out of all proportion to the detriment, including the claims of others to the same property, such as in Guest, where Andrew's siblings also expected to inherit on their parents' deaths. The need for a clean break, as again was the case in Guest, as by the time of the proceedings, it was entirely impractical to expect the parties to continue to live and work together at the farm. And, as was again the case in Guest, the fact that the repudiation of the promise took place before it was due to be performed, which often brings with it not only the issue that the promisee has not necessarily fulfilled their side of the bargain entirely, but also the fact that the promisor might well still be in need of their property. With all of this in mind, Lord Briggs set out a two-stage approach to proprietary estoppel claims, although in reality, the second stage doesn't take you any further than the starting point for determining the remedy. The first stage is to decide whether an equity has arisen in the first place. Was it actually unconscionable for the promisor to resolve from their promise at all? Assuming that the answer to that question is yes, it was unconscionable, it's necessary to go on to consider the second stage. However, here, in terms of determining the appropriate remedy, all that Lord Briggs seems to be suggesting is that the court will normally begin the exercise from the expectation basis. And even then, he only suggests that the usual starting point is the simplest way to remedy unconscionability, which, as previously suggested, would seem to be distinct from the best or the proper way. So the second stage perhaps gives rise to more questions than answers. For example, when is the expectation basis not the starting point? And when it is not the starting point, where do you start from instead? What is the meaning of the distinction drawn between an assumption and a presumption? Is it meant to underline that the proposed starting point has no legal or evidential status, for example? Some clarification might be found in the subsequent paragraphs of his judgment, as Lord Briggs goes on to suggest that the burden is on the promisor to prove that fulfilling the expectation would be out of all proportion to the detriment suffered. This would seem to indicate that the suggested starting point of the second stage does have some legal or evidential status, as the burden of proof is said to have shifted, with it being for the promisor to prove that the expectation-based remedy would not be appropriate, rather than for the promisee to prove that it would be. Further, it seems that the burden is quite a high one, as it must be out of all proportion and not merely just proportionate, which might be all the more difficult to establish when Lord Briggs also recognised the common difficulty of quantifying the detriment in monetary terms, which might further give the promisee the benefit of the doubt. It might also be an indication of the difficulty of persuading the court away from the expectation basis as a starting point, even though it is somewhat occasionally framed as the normal starting point. In addition, even if the promisor persuades the court away from awarding the promisee what the promisee expected to receive, contrary to what Lord Legate suggested, it does not mean that it switches to assessing the relief on the detriment basis. Instead, the court should limit the extent of the remedies so as to put right the disproportionality. And in light of this, Lord Briggs endorsed the suggestion by Lord Walker in Jennings and Rice that proprietary estoppel cases fall on the spectrum, with quasi-contractual cases at one end, where fulfilling the expectation is most likely to be appropriate in circumstances where the detriment has also been undertaken in full, which further confirms that the approach to remedy is not one of making a binary choice between two bases for assessment, as Lord Legate suggested, but one of moving along a sliding scale. As well as addressing the spectrum proposed by Lord Walker, Lord Briggs also addressed Lord Scarman's reference to the minimum equity to justice in Crabbe and Arran District Council, as it is often this phrase which is used to try and cut down the relief awarded from the expectation basis to the detriment basis, as was argued on behalf of the parents it should be, and as was alluded to by Lord Legate. However, Lord Briggs makes it clear that that is not how Lord Scarman's words should be interpreted. It is not a case of attempting to quantify the expectation and the detriment, and then awarding whichever is the lower. Instead, those words mean nothing more than identifying a remedy which will be sufficient to negative the unconscionability of the promisor reneging on the promise. While this reframing perhaps doesn't add anything much to Lord Scarman's words, the focus on sufficiency, particularly when taken with Lord Briggs' clear dismissal of simply awarding the lower of the two rival bases, will at least make it harder for defendants to argue that a remedy should be reduced because it is not the bare minimum that could be awarded. Lord Briggs does then go on to note the other matters which can result in a lesser remedy than specific performance of the promise, such as acceleration, the need of the promisor to pay for care, the need for a clean break, and specific performance being out of all proportion to the detriment. But very little guidance is given as to how to address them. For example, the relief might need to be discounted to account for the expectation having been accelerated, but that leaves the question of by how much. Similarly, while it's suggested that the remedy might have to accommodate the risk that the promisor needs to rely on part of the promised property to pay for care, again, it is not clear how that should be done, let alone how great the risk should be before it becomes a factor. And finally, if the issue is that full enforcement would be out of all proportion to the detriment, Lord Briggs can only suggest that the court will just have to do the best it can. A little guidance can, though, be derived from the award which Lord Briggs ultimately made. As indicated, he did allow the appeal, and consequently, he redetermined the appropriate remedy, in particular, including a general discount for early receipt, something which he felt the first instance judge had not allowed for in his award. Therefore, while Andrew would still receive 50% of the farming business, Lord Briggs altered the award in respect of the farm itself. Although the award was still referable to 40% of the farm, Lord Briggs offered the defendants two options as to the form of the relief. Either, if his parents wished not to have to sell early, Andrew would receive 40% of the farm, but subject to a life interest in favour of his parents in the whole farm rather than just the farmhouse, as had been ordered at first instance. Or, if his parents wanted to achieve an entirely clean break, he would receive 40% of the value of the farm, discounted by the value of his parents' life interest. Therefore, although Lord Briggs didn't deviate hugely from the remedy awarded at first instance, he did give at least greater weight to the acceleration of the relief. So, where are we now? I had hoped that by now there would be some reported first instance decisions showing how Lord Briggs' judgment was being interpreted, but it doesn't seem that the courts have yet had to grapple with this approach to remedy, at least in any reported cases. However, there is a hint at how the court might deal with it in the recent case of Mate and Mate, which was handed down in February this year, and which Chris has already taken us through in relation to whether an equity was established. Although the proprietary estoppel claim failed, the judge did give short shrift to the suggestion on behalf of the defendants that while the expectation was the starting point, the equity should be satisfied by reference to the detriment suffered. And it is also worth noting that although the proprietary estoppel claim failed, the claimant's unjust enrichment claim was successful, and she was awarded just over £650,000, albeit this represented just 7.5% of the uplift of £8.7 million in the value of the land which had been generated by her work. And so it was a fraction of the value of what she might have recovered if her proprietary estoppel claim had succeeded. In any case, unfortunately, it seems that we will have to wait to see how the courts engage with the more difficult subtleties of Lord Briggs's judgment. On the other hand, though, one thing which I think is clear is the need for defendants to be ready to deal with remedy, even if it is their primary position that the issue doesn't arise because no equity arises. The fact that the defendants did not really engage with the appropriate remedy at first instance and guessed certainly caused them and the judge problems, and perhaps the appeals could have been avoided if the issue of acceleration had been properly argued at first instance. This need is only underlined by Lord Briggs stating that it is for the defendants to prove that the fulfilment of the expectation is out of all proportion to the detriment. And although the court was at no stage in guess particularly concerned by the tax consequences of the relief granted, and instead sought to avoid grappling with them by either ordering that they should simply be shared between the parties, or giving the defendants the ability to avoid the tax consequences of a lifetime disposition of the farm by choosing not to sell, it would still seem sensible to be in a position to address the court on the tax consequences of the most likely potential forms of relief, not least to try and avoid an award backfiring and leaving all parties in difficult financial circumstances. So thanks everybody for your time. That's all from me on remedies, but Chris and I will be very pleased to try and answer any questions which you might have.
Yes, if anyone has any questions, if you want to put them into the chat box, that will come through to us and Annie and I will address them as best we can. Equally, if you don't want to post a question now, if you want to just contact us, please feel free to do so. Email us, give us a call. We're happy to chat. It's a really interesting topic and it's always very nice to chat through cases and scenarios with people. If you're not going to ask any questions, could I just remind you what I said at the outset? If you do have a minute, if you could please complete the feedback forms. We really do appreciate it. We take on board your comments. Apart from anything else, it allows us to work out what we can talk to you about next time round. So if there's something that's you think is interesting and no one's talking about it and you'd like us to talk about it, then let us know and we'll give it a shot. Doesn't seem as though anyone has any burning questions they want to pose. We're all keen to get back to finishing work and to getting outside and enjoying the sunshine. So I'm going to close the webinar down now, but thank you all once again for coming. And look forward to seeing you at the next webinar that we do, or maybe at one of our face-to-face workshops or seminars. Thank you very much.